give a little talk on multifamily and multifamily investing, raising money for multifamily, and all that kind of jazz. So start off, as I always do, with my mandatory disclaimer that this is not legal advice. This is not a legal consultation. I'm not acting as your attorney in this presentation. If I were, this presentation would cost a lot more than you're paying for it. So please take this only for informational and educational purposes and consult your own professional advisors before doing anything ever. Thanks a lot. Okay. So multifamily. What I wanted to do today was just give you an overview of multifamily transactions start to finish. In my own practice, I've represented dozens and dozens of multifamily transactions, as well as the securities offerings that are funding them. Everything from deals that are less than $500,000 all the way up to $75 million, everything in between. So we're just going to kind of walk through the process A to Z, and what to expect in your multifamily transaction, and also what to do about raising money and doing it legally, and when you should do everything. I will qualify that I'm not here to teach you multifamily investing. I'm not here to teach you how to make money in multifamily. There are mentoring groups and education groups and people out there that are far more qualified than I am to do that. And that's not my purpose. Don't think that after this webinar, you're going to be a hotshot multifamily investor. That's not going to be the case. Definitely get yourself educated. There's a lot of mentors out there teaching this stuff that take this kind of ready, fire, aim approach. And I really think in these types of transactions, that's a dangerous approach. I mean, you think about just the literal ready, fire, aim is a great way to get yourself arrested and a great way to injure other people and cause a lot of damage. You don't want to do that. You don't want to go into these transactions blind or uneducated. I actually had a guy call me one day and he was like, "Hey, I need an attorney. I just put an apartment complex under contract." And I was like, "Oh, great. Yeah. Tell me about the deal." It's like, "Okay, it's this many units. It's $5 million. And I said, "Cool. So, are you syndicating?" And he goes, "What's that?" And I said, "Well, that's, raising money from investors for your apartment. Do you have, $200,000 or so cash to take this apartment down? Or sorry, $2 million or so to take this apartment down?" And he was like, "No." Like, you get my point. It's like this guy was really buying into just like, jump and build the parachute on the way down. And, these transactions are high dollar. They're very short time period that you have to do them in. It is, you don't want to just put an apartment under contract and then figure out how to do it. You need to get all your ducks in a row ahead of time, get educated before you start. So just wanted to throw that out there because I have talked with a lot of people who just simply aren't ready to do this. They haven't done their homework. So do your homework. Okay. So who's going to be involved in the transaction? It's not something you're going to do alone. And I highly recommend that you form a team of professionals to do this. And the team players you're going to need, I would start with a real estate broker. I know you don't have to have a real estate broker, but deal after deal after deal, I see real estate brokers really making a difference, especially in being able to win the deal in the first place. It's a very competitive seller's market that we're in right now. There's a lot of people trying to jump in the game. And if, an experienced real estate broker who's in the good old boys club can really make a difference in getting your offer accepted versus someone else's. In addition, a mortgage broker, I've seen more than a few deals saved by a mortgage broker where a lender backed out at the last minute. And if it wasn't for the mortgage broker having 2 or 3 others lined up ready to go, the deal would have collapsed and the investor would have lost a lot of money. So mortgage brokers are super important to your deal. Insurance brokers, obviously you need to have insurance ready to go when you close on the property so that nothing goes wrong. Now, for all these individuals, you want someone who is experienced and active specifically in multifamily. not just someone that does house, not someone that does commercial. It's multifamily. It's its own animal. It has its own quirks. And having people that are in the thick of it really makes a difference from just someone who does real estate generally or single family real estate. It's not the same. So these people should all be on your team. Now there's two, and I'll qualify most of this presentation, which I am with the fact that I'm way oversimplifying. I'm for the time constraints and everything. So obviously this is not comprehensive of every single aspect, but in general is what I'm trying to give here. So two basic ways that people buy multifamily. So the first way is just do it on your own. You bring your own money. It's just you and your lender. You run everything. That's called being an independent rental owner, or an IRO. And then there's bringing in other people, bringing in money investors to help you take down larger deals, and that's becoming a securities issuer, either a syndicator or a fund manager. And the difference between being a syndicator or a fund manager is syndicator has a specific deal, a specific property they're going to buy, and then they go raise money for that property, whereas a fund raises money for the idea of buying a property. I don't know if anyone can hear me right now. All right, I don't know what happened there, but my Zoom seems to have disappeared and come back. So hopefully our broadcast is still going. Kennedy, are you there? Can you tell me what happened with our technical difficulties, and can anyone hear me now?
Sorry, everyone. I think Zoom just kind of disappeared and came back, but I think we are good to go.
Are all our attendees in?
Yes, seems like yes, everybody's here.
Okay, I'm just going to roll back to the beginning of that slide because I don't know exactly where we got cut off. I'm just going to, show must go on, so I'm going to keep on keeping on. Thanks. All right, so I'm going to qualify this presentation with the fact that I'm greatly oversimplifying things. So there's a lot of nuance and there's a lot of different aspects to this. I can't possibly touch it all within time constraints. So, what I'm giving you here is kind of a rough, in general, how things go. So generally, there's two ways that people buy multifamily. And the first is on their own, independently, use their own money. They run things themselves, just them and their lender. And that's called being an independent rental owner. It's just you buy the property, you run it, and that's the end of the deal. The second way is to bring in investors, bring in money partners to help scale and do bigger and better deals. And that's being a securities issuer. Securities issuers might be syndicators or they might be fund managers. And the difference is a syndicator has a specific property that they're pursuing, and they're raising money to buy that property, whereas a fund manager is raising money to buy something. They don't specifically know what yet, but they raise all the money and then they find the thing to buy. Either way that's done, you come under the purview of the Securities and Exchange Commission, and you have to follow all of their rules and regulations or get yourself into big trouble. Okay, so that means if you're going to take that second route and you're going to be raising money, we need to add another player to your team, and that is a securities attorney. I've noticed the real estate attorney and the securities attorney are not the same job. So two different hats. The real estate on one hand, the securities offering on the other hand. This is not necessarily going to be handled by the same person. Not all real estate attorneys can do securities, not all securities attorneys can do real estate. So you need to make sure that you have people that can do both of those roles in your deal. I personally do both. I'm a real estate attorney and a syndication attorney, but not all attorneys work that way. So make sure that you have the proper players on your team and not just, oh yeah, I can do that too, when they've never done it before. Okay, so going forward, I'm just going to assume there's going to be a securities transaction in the deal. If you aren't doing a securities transaction, if you're going to do an IRO, then just ignore the security stuff and everything else kind of falls into place. But basically there's two transactions that are happening simultaneously as we go from beginning to end here. So we have the real estate transaction on the one hand, and we have the securities offering on the other hand, and you're going to have to be juggling both of those on the way to getting your property closed. And your timeline for this, generally between 65 and 75 days. It varies. Typical contract is going to be 60 days, but you've had some like negotiation time before that. So let's say 65, 75 days to get everything done here. All right, so what kicks everything off is a letter of intent. And the letter of intent is just your cocktail napkin discussion of the transaction. So it's just a letter, super informal, that just talks about what are the basic terms in our transaction. The kind of the big picture items. What's the price of the property? How much earnest money are we going to put down? Earnest money is just the good faith deposit that you put into escrow, to show you're serious about the deal. Escrow holds a certain amount of money on your behalf until closing. Is there an inspection period? Do you have a period of time where you get to inspect the property? And if you discover something during that time that you don't like about the property, you don't want to do the deal anymore, you can back out. Sometimes there's an inspection period, sometimes there isn't. I'll add in here, and this is not usually put in the LOI, but I think it's important when talking about inspection periods. Inspection periods must have independent consideration. One of the first things they teach you in contracts class in law school is that contracts have to have consideration. There has to be something given for something in return. If you have an inspection period as a buyer that says, within 15 days or 30 days, the buyer can terminate and walk away and get all their money back, you literally don't have a contract because you're able to walk away without leaving anything on the table. So when you look at a multifamily purchase agreement, there should be, if there's an inspection period, there should also be a certain dollar amount that is the independent consideration. It's the money you're paying for the right to walk away. And that's what keeps the seller tied in the contract. If you don't have independent consideration, you don't have a contract. And that means the seller could walk away, find someone that'll pay a bigger price and just leave you out cold. So make sure that that's included in your deal. Probably won't be mentioned in the LOI, but just because I was talking about inspection periods, I figured that was a good place to do that. All right. If there's a financing contingency, it's usually going to be in the LOI. So if I don't, get a loan at such and such percent approved within so many days, I can back out of the agreement. That's a financing contingency. Again, may or may not have that in your deal. And then finally, when do we expect to close? 60 days after the contract or what? All those things will be put in the LOI or the letter of intent. Any deal breakers for you. If there's something you have to have, or you're going to walk away, put it in your LOI so you're not further down in the more expensive portion of the negotiations before deciding you can't do the deal. So anything that's critical to you needs to be in your LOI. One thing about LOIs is they're not binding. So even though it looks like a contract or a letter agreement and it's signed by both parties, it doesn't actually obligate the parties to do anything. So really, either of the parties could come back and be like, I don't like that price after all. I want this other price or whatever. There's nothing holding them to it. Occasionally, they will put a binding confidentiality. Something popped up on my screen. I got distracted. Occasionally, they will put a confidentiality provision that is binding. It says, okay, this is non-binding except that the parties will keep the terms of this negotiation confidential. Frankly, I think that's a little bit silly because what you're doing is you're spilling the beans and saying, well, here's what I'm willing to pay and here's all the terms I'm willing to meet. Please sign this and keep it confidential. Well, if they don't sign it, they don't have to keep it confidential. So you've already conveyed the information. They can do whatever they want with it. And they're not obligated to keep it confidential unless they sign. So if you want the terms of your offer to be kept confidential, you need to secure that ahead of time in writing before you give them your LOI or before you disclose what you're doing. So Anyway, but you see them in there for some reason. And whatever. All right. After the letter of intent comes a purchase agreement, and there's two basic ways purchase agreements done. They're either done on promulgated forms or with proprietary agreements. The promulgated forms, every state has these. It's, you know, the state real estate association puts them out, and it's usually 10 or 15 pages with the basic terms that you need to get a deal closed. Generally, they're pretty fair. They cover most of the stuff that you would want in your agreement. And I really like these because they, you know, the attorneys dealing with the transactions and the brokers dealing with the transactions are really familiar with them. So they know ahead of time without having to, you know, read a whole lot of stuff. They know what the terms are. On the other end of the spectrum, these proprietary agreements, and these are, you know, when you have a law firm that's billing you by the hour, they want to maximize their revenue. So they write, you know, I've seen these as long as 70 pages where, you know, it's the same stuff that's in the promulgated form, probably with a few more caveats or a few more things taken care of. Generally, I think they're overkill. Always they're going to be slanted again, you know, toward the side that drafted it. So there's a lot more negotiation and haggling that goes into dealing with these. So I like the promulgated forms. They're not perfect. I like adding an addendum, but it's far easier to argue with the other side about, you know, a 2 or 3 page addendum than about a 70-page purchase agreement. So, but don't always get my way. So sometimes we have to deal with proprietary ones, and just have to read every word and find the stuff that's disagreeable and hash it out. Either way, there are terms that I always want to see, or at least try to get into my purchase agreements. One is additional due diligence materials. So these promulgated forms will have a generic list of things that the seller needs to provide to the buyer for them to analyze the property. But a lot of times they don't have all the stuff you need. So as a buyer, you've talked with your insurer, you've talked with your potential lender, you have an idea of the things they need. You need to make sure that your due diligence materials are in your contract so you can get that stuff from the seller. Financials are a really important one because the value of a multifamily property is based on its income. Related to that, I don't always succeed, but I try to get a minimum economic occupancy provision. Economic occupancy is that how much money would the property take in every month if we rented out 100% of the units and everybody paid their rent on time. And then whatever percentage they actually collect in a particular month, that's their economic occupancy. And this is important because the loan is going to be based on the value of the property, which is going to be based on the income. If that income drops, the amount you can get in your loan drops, or it might kill your loan altogether. And a tendency of sellers a lot of times is to just kind of stop paying attention to their property once it's under contract to sell. And then, you know, the collections go down, the income goes down, and all of a sudden the deal doesn't come viable. So when I can, I get this, you know, the seller's going to maintain this level of economic occupancy. And if they don't, we're going to extend the time so they can bring it back up, or we're going to do something to ensure that their poor running of the property doesn't ruin our buyer's loan. Similarly, make ready penalty. So we want to make sure that when we buy a property, that vacant units are ready to rent. And if they're not, I want the seller to give me some money to pay for fixing them up and getting them ready to rent. Extensions, especially since COVID-19, extensions have become super important. I had about a 2-month stretch earlier this year where every single deal that I had going had to extend its closing date. There was just some kind of backup going on with lending, and we could not get anything closed on time. And so I've been insistent that, you know, we get at least one, 15-day extension. You usually have to put some money down. So we say, the buyer will deposit another $15,000 earnest money for an additional 15 days to close. I've been really adamant that we get at least one, if not 2 or 3 extension options in our agreements. Default provisions. So what happens if the seller defaults? The seller decides they don't want to do the deal anymore. What's our recourse? A lot of these contracts simply say, well, if the seller fails to close, the buyer can just get their earnest money back. Well, that's fine, except that the buyer has spent a whole lot of money doing due diligence. They've spent money doing inspections. They've done loan applications. They've given independent consideration, which hopefully your independent consideration is only like $100 or $1,000, but I've seen it where it's $25,000, $50,000. And if you don't get that back, the way most of these are written. So, I want a little more teeth in my default provisions. It says if the seller defaults, not only do I get all my money back, or not only does my client get all their money back, they also get their independent consideration back, and they get reimbursed for their actual expenses in inspecting the property, at least up to a certain amount of money. So that's something that I'll try to put into agreements. And then non-disclosure. We may not want future parties to know what we paid for the property for when we sell in the future. We don't necessarily want the tax appraisal district to know what we paid for the property. So provision that the parties will not disclose to any outside party what the purchase price of the property is something that we'll also try to get. All right. So here's our timeline. Our LOI kicks everything off within a few days to a week of the LOI. We want to have the purchase and sale agreement, or the PSA, signed. So here's our PSA, and we're just going to build this across as we go through the presentation. All right, we're under contract. Now, how do we fund this thing? Where do we get the money? Well, 60 to 80% of the money is going to come from a lender. It's going to be debt. Your lender is the biggest partner on your deal. And you want to get them involved from the get-go. Hopefully, you've already been speaking with your mortgage broker. Hopefully, you've already seen the options and you have an expectation what you can get. As soon as we're under contract, we're going to submit that loan application and try to get approved to actually fund this thing. So that's most of the money right there. The other 20 to 40% is going to be equity. Now, again, if you're doing an IRO, that's your money. If you are doing a securities offering, that's your investor's money. And that's where we need to engage your securities attorney and get things rolling on that end. So important to know, if you're raising money from passive investors, you are selling securities. Securities, at least in the United States, must be registered, or they must qualify for an exemption from registration. Super important. You can do this yourself. I'm kidding. Don't do this yourself. Don't sell securities without the guidance of a securities attorney. The laws are complicated. The laws are constantly changing. I do mostly Reg D offerings. Reg D offering, the rules around Reg D offerings have changed twice since December. So it's a very busy area of law. It's a very difficult area of law. Please, please, please don't do this yourself. Get a securities attorney to do it. I go a little bit deeper into this stuff in another webinar you can watch on our YouTube channel, the Crowdfunding Lawyers YouTube channel, on structuring syndications, where I get more into the securities rules and how, who you can raise money from and how. I'm not going to go quite that deep here. I will talk about there's several exemptions from registration that you can operate under when you're doing these. And that largely depends on who your investors are. So if you think about who you expect to be the people that put money into your deal, that will affect how your securities offering is structured, under what rules it's using. So for instance, if you want to raise money just from the general public, just from Joe Everyman, there's what's called regulation crowdfunding. It allows you to raise up to $5 million from Joe Public. There's some restrictions on how much they can put in. It does get submitted to the SEC, but it is an option for, if you're a social media influencer and that's where your investors are going to be. There's regulation crowdfunding allows you to reach out to them. Regulation A is similar. It allows you to raise actually up to $75 million now, but it does have to be qualified with the SEC, which is a very long, very expensive process. Probably not great for a syndication because your purchase agreement's probably not going to give you enough time to get a Regulation A offering off the ground. If you're doing a fund where you're going to raise money ahead of time and then buy apartments, Regulation A might work. If you expect your investors to just be wealthy people or institutional investors, family offices, stuff like that, but who you don't already know, there's what's called Regulation D 506C, which lets you publicly advertise for investors, but you're limited to only accredited investors. And for all practical purposes, accredited means rich people. People that have high income or high net worth are accredited. And again, watch that other video on YouTube for more details. If instead you're going to raise money from your own personal network of investors, you can raise money from both accredited and non-accredited investors under Regulation D, Rule 506B. The trick with 506B is you can't publicly advertise. So everybody has to come to you without you advertising, no Facebook posts, no Instagram, no billboards, radio ads, none of that, strictly through people you already have this relationship with. And then occasionally I come across a deal, not too often. I'm actually doing one right now where we're just raising a little bit of money from a small number of friends and family. They're all in the same state. And a great option for that is called Regulation D, Rule 504. And in a nutshell, Rule 504 punts to state securities laws. And you can raise money under your state's securities laws without worrying about the SEC, except for a simple notice filing. So those are the options. Get into more detail in other webinars, but putting those out there. 506B, by the way, is the granddaddy. Like that's the overwhelming majority of private offerings are 506B. So probably that's the one you're going to end up doing. Anyway, let your securities attorney guide you. Okay. So our process, gross oversimplification, is where our attorney puts together the documents. We submit our documents to investors. That includes our PPM, our private placement memorandum, which is kind of like a prospectus. It gives all the information and all the warnings and all the risk factors and stuff about the deal. Our subscription documents, which is where investors sign up to invest. We collect their subscriptions, we collect their capital contributions, and then we immediately flee to Mexico. No, sorry, I meant to take that out. We collect our capital contributions and we hold them until closing. And that could be held in an escrow account, or it could be held in just a separate account that your LLC sets up. But don't touch the money until you close on the property. Now, your offering documents most likely are going to have a minimum offering amount, after which, once you've raised that amount, you can do what's called break impounds, which just means use investor money. But when you're syndicating a deal like this, I recommend not touching that money. And the reason is if you break impounds and you start using the money to pay for the inspections and pay for the loan fees, and all this stuff, and then something happens and the deal falls through and you can't close, now you've got a whole bunch of really mad investors because they've lost a bunch of money and don't have anything to show for it. And that's just not good for anybody. So just leave their money alone. Use your own money for all your preliminary stuff. And then at closing, you can have the investors reimburse you for your out-of-pocket costs. But make sure that property's in hand before you start spending investors' money. Just best practice. And then along the way, as we're collecting subscriptions and capital contributions, you're going to be filing securities notice filings. Your securities attorney or your law firm should assist you with that. So back to our timeline, about the same time, just right after the PSA, we know we got the property, we're going to do this offering. Get your attorney, start drafting offering documents. Generally, this is a 2 or 3 week process. We get our offering out to investors, and then as we start bringing in money, there's a short window of 15 days to file those securities notice filings. So that timeline is running pretty much from the start. Okay. Shortly after we have our PSA signed and given to the title company, they are going to give us a title commitment. What's title commitment? It's a document that pretty much everybody ignores and doesn't know anything about. That's not a good thing. So the title commitment is a document you get from the title insurance company that gives you kind of the initial details of here's what the title policies are gonna look like. And it's going to have all information about who the parties are, who the insured is. There's an owner policy for you. There's a lender policy for your lender. How much money is going to be covered? Generally, the price of the property is going to be your coverage. The amount of the loan, so 75-80% of the cost of the property is going to be the size of the loan policy. Legal description of the property. Various and sundry other things. One of the most important things that's going to be there is an exception list. And it's a list of here's all the things that we're not insuring against. In other words, if any of these things end up costing you money, you're out of luck as far as collecting your property insurance, title insurance. So restrictive covenants that say you can't operate this kind of property. Or city ordinances, easements, mineral rights. This varies by state, but in Texas, for instance, the mineral estate is superior to the surface estate. So the people that have rights to drill oil on your land actually have more right to your land than you do. They're not. The title insurance company generally does not want to insure against cost to you of someone exercising their mineral rights. Any recorded contracts like laundry leases. The joke is if there's ever a nuclear holocaust, the only thing that will survive are cockroaches and laundry leases. Laundry leases are generally recorded and they run with the land. They last forever. They're terrible. So if there's any cost to you or damages to you because of your laundry lease, title insurance is not going to cover it. Any encroachments that show up on the survey. So if you've got a fence or a building that crosses the property line, if you have an expense where you're forced to remove it or something, your title insurance is not going to cover that. So these will all be listed out on that commitment. And all these things come from either public records or from the survey, whatnot. So your attorney's job then is to take this and first of all, review it, check everything for accuracy, make sure that the legal description is correct, make sure the party names and the dollar amounts are correct. And then object in writing to all the mistakes that I guarantee you will be on it, and demand that the title company and or the seller get those things fixed. It's called a title objection letter. It's usually due in about a week of receiving the survey and the title commitment. So this is something very important that your counsel ought to be taking care of for you. And in the same letter, they should also be requesting any policy endorsements that are appropriate. So we have all these exceptions. On some of these, you may want to purchase additional insurance and insure around the exceptions. You can pay extra money to have certain things insured. Let your attorney guide you on which endorsements should be purchased. All right, so that's going to come up right here shortly after your loan application. So usually within a week or two of the PSA being delivered to the title company, you'll get the title commitment. About a week after that, within a week after that, your counsel should submit their title objection letter. All right. Now, most PSAs have a provision that if the seller or the title company fails to cure your title objections, you can terminate the contract. And that sounds great. I've got another out. I got another way of getting out of the deal. It generally doesn't actually help that much because especially if you already have a feasibility period, because that's probably going to be well within the feasibility period when you can terminate. And under feasibility, you can terminate anyway. So it's not really anything additional. As we move down, generally 15 to 30 days after the purchase agreement is signed is the end of feasibility. And at that point, that means your earnest money goes hard. It becomes non-refundable. So if you have to put up $25,000, $50,000, $100,000, whatever earnest money at the beginning, if you don't terminate before the end of your feasibility period, you've lost that money. And the only way really to get it is to go through with closing so you have a property at least to show for. All right. Next comes lender due diligence. And this varies based on the lender, the type of the loan, size of the loan. Sometimes lenders don't request any due diligence. Sometimes lenders drive us crazy requesting anything and everything under the sun. Agencies almost always, Freddie Mac, Fannie Mae almost always have a laundry list of due diligence items they want. Smaller, like credit union loans, and a lot of times don't have any. But things that you might see if there is lender due diligence request, things that they might request from you are legal opinion, saying that the borrower exists in good standing in the state, is allowed to do business, he's not going to violate any contracts or any laws purchasing the property. They may want the formation documents of the LLC that's going to purchase the property. Certificates of good standing, which is just a letter from the state saying, yes, this entity can do business in our state. Incumbency certificates, that's just information about the manager and the manager's role in the company. They may want an org chart showing everybody's ownership and everybody's management authority. Resolutions authorizing the company to borrow money. They may do searches, background searches for whether the company's being sued, whether there's liens or judgments, bankruptcies, whatever. All those things are frequently requested by lenders, and your real estate counsel ought to be able to handle just about everything that they request. Okay. Then we'll have loan documents. If we're lucky, we'll get draft loan documents first, and we'll have a little bit of time to review them. And then they'll send us final loan documents with all the blanks filled in closer to closing. It gives us more time to review. Either way, loan documents are going to generally include a loan agreement, which is kind of an overarching agreement about how the loan's going to work, the obligations of the borrower. Maybe the borrower needs to do a certain number of repairs within a certain amount of time. It'll have information on recourse, whether you're recourse or non-recourse. By the way, there's no such thing as a non-recourse loan. It's a misnomer. But what things could cause a loan to be recourse? Recourse means that they can go after you personally, or go after a guarantor personally for money if the loan is not paid. You have the note, which is just the promissory note that says, I will pay this much money by this date with this much interest. A deed of trust, or the mortgage, which is the security instrument that's filed that shows that the lender can take the property if the loan is not paid. Guarantee is a personal guarantee usually by the manager of the LLC that's buying the property. Sometimes you'll have if your net worth isn't high enough, you'll have other people be guarantors. Those are the people that the bank can go after if you don't pay the loan. An assignment of rents. This one confuses people. So, an assignment of rent, it basically says the lender hereby owns all the rents. Any rent collected by the property belongs to the lender. And you go, my God, why would I do that? How would I make any money? And the way it works is we assign all the rents to the lender, and then the lender gifts us the rents back as long as there's no default on the loan. So, okay, we own them, but as long as you do everything you're supposed to do and you pay your mortgage on time and everything, you can keep the rent money and use it for your own purposes. And then you'll occasionally see other miscellaneous documents. So affidavits that you're only going to do this for a business purpose. You're not going to live at the property. Financing statements, which is kind of like a mortgage, but on personal property. Gives them a lien against personal property and fixtures. Indemnities. So, for instance, there's an environmental issue, you're going to make sure that everything's paid for and your lender's not going to be responsible, et cetera, et cetera, et cetera. It varies. Every lender's different. Every deal is different, but those are kind of the basic documents you expect to see. Okay, so our due diligence is going to come as we're getting closer to closing, if we get it at all. Preliminary loan docs, probably sometime shortly after that, if we get them at all. And then as we get close to closing, within a week, usually we get final loan docs that have all the blanks filled in, the names, the addresses, everything, and we just do a final review to make sure there's no mistakes. Now, the smaller the loan, typically, the closer to closing all these documents come. if at all. Sometimes, especially on the real small loans, like $1 million or less, we just get final loan docs, and they will push those as far as late as they can, even though it's like a form doc that they just hit print on. Like they, for some reason, can't give it to us till the last second. I've literally gotten loan docs at 11 in the morning on closing day when the wire cutoff is 2 o'clock. So, I'm here like, okay, you review this one, you review this one, you review this one. I got all my attorneys jumping in to try to make sure all these documents are read before a client signs on the dotted line. But yeah, the smaller the deals, the later these are. Also, the more like onerous the terms seem to be. The really like sketchy stuff we find in loan documents tend to be on small loans, as opposed to the big ones. The big ones oddly enough, tend to be more fair. It's a really weird thing. I actually reviewed one yesterday, and it had 3 years where the interest rate was fixed, and then it went to a variable interest rate that the interest rate could change every 3 years after that. And the basis for the variable rate was the such and such base rate. It sounded real official. And when I look into it more, it turns out that the such and such base rate was literally whatever rate the lender wanted to charge. As long as it was below the legal limit, they could charge. So at year 3, after my client's been paying like 4% interest, like boom, they could be hit with 18% interest with no default, no nothing, just like the bank charged whatever interest they wanted. And that was so. Review those. Have your attorney review those. Make sure you catch all that stuff before you close or before you sign. Anyway, all right. Home stretch, closing documents. So we'll get these generally the week of closing, sometimes a couple of days before closing. Closing documents will include a warranty deed, which is the actual document that transfers the interest in the real property to the buyer. There's 2 kinds of these. There's a general warranty deed and a special warranty deed. And the difference is a special warranty deed is the seller warranting that they have good title or giving you good title to the property. And they had good title for the time that they owned it only. General warranty deed warrants that it's good title and the title's good since the beginning of time, since the land was unexplored frontier, all the way up to the present. So there's a big difference between general warranty deed and special warranty deed. And it's kind of subtle, the difference in the actual document. So it's not just changing the name at the top from general warranty deed to special warranty deed. Occasionally they just say warranty deed, they don't say what kind. So there's going to be language in there that looks like this. It'll be maybe not word for word, but very close to this. To have and to hold the property, blah, 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 blah. The grantor does hereby bind itself to warrant and forever defend the property, blah, 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 against every person whomsoever lawfully claiming or to claim the same, lawyers, or any part thereof, by, through, or under grantor, but not otherwise. And right here, the magic words: by, through, or under grantor, not otherwise. If that language is in there, it's a special warranty deed. If that language is missing, it's a general warranty deed. That's how you tell the difference. All right. In your warranty, also beware exceptions. A lot of times they'll be like, we grant the property to the grantee subject to the exceptions, and they'll have a list of exceptions. And I've seen these where the exceptions swallow the entire thing, and they're not actually guaranteeing or warranting anything, even good title. So make sure your counsel is reviewing the exceptions. Make sure the exceptions, they should probably match the exceptions on your final title policy, and not much more than that. So, you want to make sure your counsel is looking at that and getting them to pare back those exceptions so that they don't swallow the entire deed. Okay. In addition, you'll have a bill of sale. So the warranty deed conveys the real property. A bill of sale conveys the personal property or the fixtures, all the things that's not land or buildings. And then an assignment of leases. So we're buying multifamily. The whole purpose of buying the multifamily is so we can collect on those leases and assign the leases to us. We become the new landlord. And then a tenant notice, which is just a letter that's signed by the buyer and seller that's given to all the tenants that says, hey, There's a new sheriff in town. Here's where your rent should be paid to from now on. Good luck and Godspeed. All right. And then finally, we're going to have a settlement statement. This comes from the title company or the escrow company. It's a long, ugly, complicated document. And what it is it's a ledger. It starts at the top with the purchase price, and at the bottom, how much cash is due from the buyer. We're about the buyer side. There's also seller side cash due to the seller. And then in between that is going to have debits and credits for all the different aspects of the transaction. So you're going to get a credit for your earnest money. You're going to get credit for your loan. You're going to get a debit for your lender fees, title fees, broker commissions, professional fees. That's your lawyers and accountants and whoever you had working on the deal for you. Excuse me. Tenant deposits, pro rations, which means, your taxes to date, they either credit you for the taxes up to the date of sale. Rents. So if we're closing, say, in the middle of the month, the rents they collected for this month, half of it stays with the seller because they own the property during that time, and the other half goes to the buyer for the remainder of the month. Utilities, if you have rubbed utilities, there's a lot of times a delay in when the utilities are charged and they're collected, so there'll be a pro ration option for that. All that back and forth, probably 100 lines of stuff. Finally, you get to the bottom and it says, here's how much cash the buyer has to bring to closing in order to close. That's our settlement statement. All right, so we're here. Our closing docs get to the very end, and then finally we are at closing. Hooray! Yay! Woo! Congratulations! Yay! Woo! We did it! Awesome! Great job, guys! I love it. The end. All right. Hopefully, my brother from another mother, Nate Dodson, is on the line, and we're going to finish this up with the next 10 or 12 minutes with our Q&A.
I am here, and
what's going on?
Lordy, that was a lot of information. You know what? Could you do us all a favor? Maybe go over it once more.
Yeah. Let me click this back.
Yes, if you don't mind. No, thank you so much. I mean, there is so much that goes into every one of these deals.
It's like a semester of law school right there. Just gave away for free.
I think you nailed a number of different courses between the securities law, the contracts, the entities, the real property. Holy moly, there's a lot that goes into it. And there are some people that do try to kind of handle it all themselves without counsel. And, we're also there to say he who represents himself has a fool as a lawyer. It literally even applies for the lawyers. We get blinded by what we hope to see. And so that's where it can get a little bit dicey. So
the lawyer that represents himself as a fool for a client.
Absolutely. So with that, we've got a number of questions. I know we're running a little bit low on time, but let's get through as much as we can. And Zoom was not easy to anybody today. I know that twice you just kind of disappeared for a minute and then popped back on. So
hopefully we can fix it in the mix and get this up on YouTube. So people can.
I love it. So let's kick off with, hey, when you're going into an apartment transaction, you've got the LOI. Now it's okay. Let's get the PSA, the purchase agreement, together. Who's usually providing
that? Most of the time I see that come from the seller, but it's not all the time. I get plenty of them from the buyer. If one party, but not the others, represented by a broker, a lot of times the broker, whoever's broker it is, will provide it. So it's not uncommon either way. Occasionally even we provide it. They ask us to draft it directly, and then we're the bad guys that create that, massive, I don't do 70 pages because I think it's ridiculous, but
we're the attorneys
in the promulgated forms for sure. But
so we're always the bad guys. personally, professionally, what do you prefer if you're on either side of the transaction?
I prefer my client's real estate broker to provide it. And this actually is how I've worked a lot of my deals, where and I've got a good relationship with a lot of brokers. Well, they will send me their draft. I will add my special provisions addendum and send them my requested changes to whatever they've done. And then they will send it over to the other side for the other side to argue against. That's my favorite way to do it. I think that's the most efficient way to do it. I love the promulgated forms because everybody already knows what's in them. So we don't waste 3 hours reading some new document. Everyone starts off knowing what's in there. And then there's just a handful of things we negotiate from that point. It just makes things so much easier and so much cheaper and so much more efficient to do it that way.
I love it. And so, now the purchase agreement's been signed, everything's moving forward. But then you put together the offering. Do you often see confidentiality terms within the purchase agreement? And if so, can you even talk about the deal that you're trying to buy?
Yeah, your confidentiality, if you're doing a securities offering, your confidentiality needs to carve out both your professional advisors and your potential investors. So you need to be able to tell your investors, we're buying the property for $8 million. We're getting a loan for $6 million, et cetera, et cetera, et cetera. So that your investors have to know that information. So you don't want your confidentiality. But what we don't want to do is report that on the broker databases. We don't want to report that to the state appraisal district. We don't want all that being made publicly available. Remember, these are private offerings, so what we tell our investors is still confidential.
Perfect. Here's a curveball of a question. Thank you, Roger. Would you use your investor funds for a hard money deposit?
I wouldn't touch investor funds until closing.
Well, that's the easiest answer possible.
Because if you, like I said earlier, if your deal falls through and you've spent investor money, you're gonna have some mad people on your hand, and mad people are where lawsuits come from. And you don't want that. Pay everything out of pocket yourself. Get reimbursed once the property closes. So ultimately, the company that you're creating that's buying this property pays for everything. But wait, get the deal done, and then because your investors, you have to take care of your investors. Otherwise, you're not gonna do another deal.
Absolutely. I'd like to add a little something to your answer, if you don't mind. Some of these deposits, and I've been in transactions where the hard money, money's going hard day one. It's $250,000 for some of these larger transactions. And you've got the sponsor, the promoters, and we're just like, I don't have that money. And so they want to use the investor funds. The reality is, that's a lawsuit waiting to happen, as Richard said. However, what you can do is you can borrow it from an individual while well disclosing. I mean, personally borrow it with disclosing my intended use is it's going to go hard into this transaction. If it closes, I'm going to get the money back. You're going to get paid back, and I'm going to owe you some interest. If it doesn't close, I'm going to have to figure out a way to pay you back.
Lose my house.
It never a good feeling, but honestly, you do enough of these deals, you kind of see everything happen. And I know, I've been in the middle of a deal where it was $250,000. The money went hard, the transaction didn't close, and then there was fighting. Fortunately, it was not investor funds. It was just between the lender and the promoter, but it did not turn out pretty.
And hopefully, if you're getting into a deal like that has a massive amount of money going non-refundable day one, I hope this isn't your first rodeo. Like, I hope you've knocked out 4 or 5 of these in the past, so you know how to close a deal before you start putting yourself in that kind of situation. Otherwise, just go to the next property. There's plenty of properties out there. Get it where you have an inspection period, you can get your money back, get a financing contingency where you can get your money back. Find just a more favorable deal when you're starting out. You don't have to take down these massive deals from the get-go, that are making ridiculous demands for, if you don't close, I get a $250,000 payday. It's just
crazy, but it happens.
Outrageous.
But along those same lines, kind of how big of a earnest money deposit, or when money goes hard, should you really be expecting?
I think typical is about 1% of the purchase price. So, if you're dealing in, 7-figure properties, it's not a ton of money. You start dealing in like 8-figure properties, then you're starting to have some sizable deposits. But 1% is a good, I think, kind of rule of thumb for earnest money. It's market dependent. We're in a seller's market, so we see much more difficult deals right now. And when the economy shifts and it become a buyer's market again, that's going to change.
Perfect. I'm just going to read this verbatim. What does buyers stand to lose by adding inspection contingency and then walking away after not being satisfied with the results? Same with financing contingency or title objections.
So typically what you're walking away from are your expenses in inspecting the property. So you've probably had a contractor out there, a roofer, foundation, environmental, all these different professionals doing due diligence for you. They all got to get paid. So you've paid them. You're not going to get that money back most of the time. If there's independent consideration for your inspection period, you're not going to get that. If you've made loan applications, a lot of loan applications are non-refundable. You're not going to get that back. So you're leaving that money on the table. Hopefully, you're at least going to get your earnest money back, the bulk of your earnest money back. So you're not leaving $50,000 or $250,000 with the seller because you show up and figure out the property's crap and the plumbing's shot and whatever. All the stuff they didn't tell you. Use paint and carpet.
As part of the transactions, though, at what point does that earnest money normally go hard where you're not supposed to get it back?
It normally goes hard at the end of your inspection period or the end of your feasibility period. So most of the deals I do is 15 days, occasionally 30 days, somewhere in there. So you get under contract, you've got 15 days to get all your people onto the property, look at all the units, look at the roofs, whatever, figure out, okay, is this going to work financially with all the repairs or whatever you're doing? And then at the end of that 15 days, you got to say, yep, I'm in, we're going to do it, or no, give me my money back.
Perfect. I'm going to hop to, since we only have a couple minutes left, my favorite questions. If we want to retain you, how do we reach you and what's the process?
Right there on the screen. I still have the old number. Gosh, darn it.
Well, what's the new number?
The new number is 469-444-9999. 469, which is just our local area code, 444-9999. So easy. I can't believe that's 2 webinars in a row I've left it wrong on the slide. Or just email me, richard@crowdfundinglawyers.net. Happy to talk with you about your deals and your transactions and the weather or whatever you want to talk about.
I love it. Well, make sure Richard loves to talk about river dance. So Absolutely. If you need to talk tap, give Richard a call anytime. All right, last question before we have to jump. When you're working on a Reg D, and we'll stick it to a Reg D, what's the timeline from, okay, we need to close on this property? How long is it going to take to get the offering together? And when should the attorneys get retained?
I would prefer to be retained right when you're ready to send that LOI. Just as early as if there's a deal on the horizon, or maybe even sooner, but you're going to do a deal, get everybody in place. As far as the timeline, generally Reg D offerings we can knock out in about 2 weeks, 2 to 3 weeks, contingent on the client having their business plan together, their pro forma projections. That's the spreadsheet that tells the investors all the money they're going to make. And usually you can't do that until you've actually gotten into the property and done your inspections, figured out your repairs or whatever. So like, it's hard to do that really, really early. But if the client gets in, does their due diligence, gets us their numbers, and we're in the meantime working on putting the documents together, usually about that 2-week mark is where we can get the offer. I've done them, maybe I shouldn't say this, but I've done
Don't say it. I'm going to cut you off right there.
I have done a Reg D in 2 days. It was ridiculous. It was 2 sleepless nights, but we did get one out that fast. One time, probably never again, so don't ask.
I think everybody's going to ask now. I've got a closing on Friday. Is there anything you could do for me?
I'll write you an amendment to extend closing. And then we'll talk about your securities offering after that.
And what states does crowdfunding lawyers represent? I mean, what
nationwide? We are nationwide. The securities laws are federal law. We do them all over the United States. Real estate transactions, on the other hand, are going to be on a case-by-case basis. I am licensed in Texas. My brother from another mother is licensed in Texas and Nevada. And we have a handful of lawyers that are licensed in other various states. So let us know where your property's at, and maybe we can help you with your real estate transaction, or maybe we can point you to a real estate attorney that can.
Definitely want to help. Well, with that, I'm going to let you say the final words and sneak off stage left. Thank you all.
Thank you guys so much. Actually, I have to turn on my other monitor to try to end the webinar. Thank you guys for attending. Really appreciate you guys, and we'll see you on the next one.
All right.
Everyone, bye-bye.